members, thank you very much, everybody. The mandate of the Information Regulator is twofold. So we deal with two pieces of legislation which have their roots in two different rights. So let me talk about the right to access to information first, and then I'll talk to the right to privacy and the right to data protection. So if we look at the right to access to information, that is something that was included in the Constitution specifically with an eye to the challenging issues we were facing and still face at the writing of the Constitution. And one of those most important challenges was the issue of secrecy. So we had a history of secrecy both inside South Africa, so the apartheid government had a history of secrecy, making sure information was not disclosed, banning people, banning the media. And we then had a history of secrecy in the people who had been in exile, because obviously they had to have secrecy in order to stay alive. So they couldn't let it be known where they were. Things had to be done underground. So we had a situation where everybody agreed that secrecy was a good thing, except now we're moving into a democracy. And in a democracy, we're now in a situation where we are having to make sure that we move beyond that history of secrecy. And how are we going to do that? And one of the things that was being developed at the time, and was very much something that was discussed internationally, was this question of a right to access to information. And there was quite a lot of debate at the time as to whether it was a right or not. But it was accepted that it was a right, it was put into the Constitution, and then from there it was argued that we needed to have a law that would give effect to the right. And indeed it came to pass, and the right to access to information was given effect in the Promotion of Access to Information Act. Now, there are two things I want to draw your attention to in relation to the Act. The first one is that it applied against public and private bodies. Now, if you look at private bodies, companies, individuals, that's very unusual. The reason we did that was to say that in South Africa, often you have people who are private bodies but performing a public service. So if you go to a state hospital or you go to a private hospital, you as the person experience it in the same way. And we're in a situation where we felt that you should have the same rights as against a public body or a private body. The second thing that was unusual about difficult about the Promotion of Access to Information Act is it did not have an oversight body. So there was no Information Commission at the time, and there was a strong argument for an Information Commission, and the reason for that was that we didn't want people to have to go to the courts, because the courts are so expensive, they're inaccessible, it's an access to justice issue. So that was going to be something that would return later in the story. At this point, the question of privacy came up, and it was not possible for Parliament to pass both pieces of legislation at the same time, although they're very much sisters. What then happened was the Law Reform Commission began an investigation into privacy and data protection and the protection of personal information. And the reason that we were doing that is that we were very aware that companies like Facebook, Amazon, Apple were making a lot of money. And what were they making money from? People's information. They are some of the biggest companies in the world. And the reason for that is that they continuously gather information. And I know sometimes information is talked about as the new oil. So it's something that's enormously valuable. And we wanted to be in a situation where in South Africa we had rules that would protect people from the exploitation of their personal information. But now the question, of course, is how to do that. And what happened is we established the project committee and the Law Reform Commission, and from there the investigation into what kind of legislation we needed was begun. Now, there are a couple of different things that you can look at in protecting personal information. One is where you do it, and this is the American system, where you do it one law at a time, and then you have individual contracts. And we didn't like that because of its focus on one sector at a time. We thought we had to try and cover all of the sectors altogether. And what we did was, in fact, to cover all of the sectors in one piece of legislation, which is called the Protection of Personal Information Act. That piece of legislation is there to protect personal information. What then came to pass is the return of the concern about not having an information commission or an information regulator that would help people access their rights. Because again, the question of courts and accepting that courts are very expensive, and that ordinary people are just not going to be able to exercise these rights if they don't have something that will help in terms of access. And while the protection of personal information legislation was being written, the introduction of an oversight body was put into the law, and that was the Information Regulator. And if we come to the Information Regulator itself, you would see in front of you the chair of the Information Regulator. There are 5 members of the Information Regulator. One is the full-time member who is chair. There are 2 part-time members, and I'm one of the part-time members. And then we have 2 full-time members, Lebraham Stroom and Advocate Colin Weapond. Just to say on behalf of Advocate Weapond, he was due to join us on this trip, and he sends his apologies. He was unfortunately suffered a bereavement and was not able to join us. The question was then really what powers this regulator would have. And we were in the middle of a quite an intense discussion in the country about what kinds of powers people who are ombuds, and certainly the public protector, what sort of powers they should have. And it was decided that in terms of the Information Regulator, that there should be very explicit powers for the Information Regulator to make orders in relation to our 2 sister pieces of legislation, the Access to Information Act and the Protection of Personal Information Act. And the way the regulator is structured is that there are executives who deal with both of these issues. So Mr. Nemasisi would have introduced himself as the head of the Protection of Access to Information Act division. So he's the man who deals with transparency. And then Mr. Waikonyo here is the executive head of Protection of Personal Information. So he is the man who deals with your data protection and your complaints around data protection and privacy. We set up the regulator, but the regulator took some time to actually come into operation. And as with any organization, you have to start with the founding of the organization and the hiring of staff, the development of an identity, corporate identity, logos, and then also just the structure of the organization, how it would be set up. So that's been part of the journey of the regulator. And then what we've also had is the development of our thinking about different kinds of ways that we should be engaging with people in order to explain what our mandate is and what we do. And I think Chair and the members have been very clear that they want us as the regulator to make sure that we reach out beyond the metros, that is not, that is not the most important thing. It's where we spend a lot of time, but in fact we have a very strong education and communication mandate. And Mr. Dimber introduced himself earlier, and he is the head of education and communication. And we've specifically said that we would like to have a interface with municipalities, and there's a very good reason for that. And as you will know, and you certainly don't need me to say this, you're really at the coalface of delivery. And so it's super important that everybody is empowered with knowledge as to how the legislation works and what the different requirements are, and again coming back to the mandate of the regulator as to what our role can be. So as I've said, there's education and communication, and that's both outreach in terms of communication, and then of course education, and we are available to do training. We do it online, we do it virtually, we do it in person. Sometimes the members are asked to come and address workshops, which we're very happy to do. And there's also a lot of materials that are being developed and have been developed by our Education and Communication Division, which we feel are helpful and which we'd be very happy to share with you if that's appropriate. To come back to our two pieces of legislation, in terms of access to information, the process for requesting information is such that the first step is usually there's somebody who does a request for information, and they usually use a form to do that on, and it's Form 2, and you fill that form in, and that's the first time you guys would see that there is a request for information. And you can have, in this instance, it would be to government. That's a public body, those are public records, but there is a list in the Access to Information Act of reasons why you can't disclose records. So if somebody asks you for the map of your local police station and where all the cells are, you would obviously refuse that. There's basis in the Act to do that. But in most cases, the assumption is that if a public body is collecting information, it's for a public purpose, it's in the public interest, for the public good, and the public should be able to see those records and go from there. If for any reason there's a refusal of the record, that person in the context of local government would have the right to appeal, and they would appeal to Madam Speaker, and as a responsible party, it would still go through your bureaucracy. It wouldn't come directly to you, and then there would be an opportunity to review the decision. Once that happens, the person who's making the request has a couple of different options. Let's just say they've been turned down, because that's the more interesting scenario. What happens when you're turned down is that you can go to court. Of course, we know that that's an expensive and difficult route, but people do that. And we encourage people to do this, is you can come to us. And the reason you come to us is that we are free, which is always good, and we can provide expert assistance in helping to mediate. So a lot of our job is to try and make sure that people meet each other, make sure that they agree the information that will be made available, and that's a lot of what Mr. Nemisisi does. And then where that's not possible, we refer the appeal to what is called the Enforcement Committee. And the Enforcement Committee is a group of primarily lawyers. It's headed by a senior advocate, a referee, and they are then in a position to make a decision as to whether the record should be released or not. And we have some cases underway. We will get a recommendation as a regulator from the Enforcement Committee, and then we make the decision. And our orders are similar in effect to court orders. It's an order power, and our orders have to be complied with. So that's the sort of one area for the regulator. The second area, the Protection of Personal Information Act, I'm sure you've received those annoying calls from the direct marketers who phone you, and they want to know, would you like to buy more insurance, and do you need a new phone? And that's really one of the consequences of people misusing personal information. There are a range of in the Act, there are a range of rules as to how you're supposed to process personal information. And I think they can be reduced to really two big things to remember whenever you're dealing with personal information. This would apply to the municipality as well, because of course you receive personal information from your constituency. And the first one is that you have to gather your information for a good reason. You can't just take a database of people's names and buy it, and that's obviously completely unacceptable. You have to ideally make sure that people know their information is being gathered, they consent. Very often with big computer systems, and this is where our CIO comes in, you have to make sure that when you're building those systems that you know that the computer knows what personal information is. So it's all very well us knowing as humans, but the computer also needs to know that. And once you've gathered that information and you hold it, and you obviously are a holder of personal information, there's the issue of making sure that it's protected, that it's safe, that there are safeguards in terms of data breaches or data leaks. And again, that's one of the areas where our CIO is an expert, and we are then in a situation where our personal information is held by the municipality and is done so safely. There's one aspect, and the sort of final aspect, and I'll start wrapping up, Chair. The final aspect is the question of the destruction of information. And this is the hard bit, and the reason I think it's the hard bit is because records management is hard.
A minute left.
The records management is difficult because it takes people, and we often don't have people to do records management. And it's often not considered that key as a role in a municipality. But there is, of course, the need, once you don't need the information anymore, to destroy the record and make sure that you don't keep it. So it's the gathering, it's the making sure that it's safe, and then once you don't need it anymore, the destruction of it. And that's really the issue that we have oversight of. If any of those conditions are breached, we then have the power to make orders in that regard, which would include reasonably substantial fines, which we haven't yet handed down, but that is one of the things that we are able to do. Thank you very much for your attention.